The day Margaret Chen, president of the Pinewood Estates Homeowners Association, served me with a formal trespassing notice for building a garden shed on my own property. I actually laughed out loud because the absurdity was so complete, so perfectly ridiculous, that I genuinely thought it was some kind of neighborhood prank or mistaken identity situation. I'm David Rosario, 47 years old, a civil engineer who'd spent the last 23 years designing municipal infrastructure projects across Oregon. My wife, Anna, a high school literature teacher, had fallen in love with the wraparound porch and the reading nook in the master bedroom, and our teenage son, Miguel, couldn't wait to finally have space for the recording studio he'd been begging for since he picked up guitar 3 years ago. We'd done our due diligence before buying, hired a real estate attorney, reviewed the title, confirmed property boundaries with a surveyor, checked for easements and encumbrances, and most importantly, verified that our property was not part of any homeowners association. The property had been a standalone farm parcel since the 1940s, predating the Pinewood Estates subdivision that had been developed on adjacent land in 1998, and our deed explicitly stated we had no HOA affiliation, no CC&R obligations, and no architectural review requirements. We were fully independent, which was exactly what we wanted after years of apartment living with paper-thin walls and neighbors who complained if you sneezed after 9 p.m. The previous owners, an elderly couple named the Hutchinsons, had maintained the property beautifully, but never made major improvements, and when we closed in early March, they'd mentioned in passing that the HOA next door sometimes gets confused about property lines, but assured us it had never been a real problem. I should have asked more questions about that comment, but hindsight is always crystal clear. And at the time, I was just excited to finally own land, real land, with mature trees and soil I could actually dig into without hitting concrete. The first 3 months were blissful. I spent weekends clearing brush. Anna planted a vegetable garden that was already producing lettuce and radishes. Miguel set up his equipment in the converted barn, and we hosted my parents and Anna's sister for a Memorial Day barbecue that felt like a scene from a lifestyle magazine. Our nearest neighbors were the Kowalskis, a retired couple who lived on 5 acres to our east, and who had welcomed us with homemade pierogi and warnings about the deer eating everything if we didn't fence the garden properly, and the Andersons, a young family with 3 kids who lived on 10 acres to our north, and who were just grateful to have neighbors closer to their age after years of isolation. To our west and south lay Pinewood Estates, a planned community of about 70 homes on quarter-acre lots, all uniform beige and gray exteriors, with identical mailboxes and manicured lawns that looked like they were trimmed with scissors, and I'd occasionally see residents out walking dogs or jogging. But we had no interaction with them whatsoever because, again, we weren't part of their community. Margaret Chen entered my life on a humid Saturday morning in late June when I was laying the foundation for a 12-foot or 16-foot garden shed near the back edge of my property, about 40 feet from the western property line that separated my land from Pinewood Estates. I'd pulled permits from the county. Washington County requires permits for structures over 200 square feet, and mine was 192 square feet. So technically I didn't need one, but I'd gotten one anyway because I am an engineer, and I do things by the book, and I'd confirmed with my surveyor that the shed location was well within my property boundaries with a 45-foot setback from the neighbor's line, exceeding the required 20-foot setback by a comfortable margin. I was mixing concrete, sweating through my Oregon State t-shirt, listening to a podcast about the history of the Panama Canal, when I heard a woman's voice behind me say, "Excuse me, you're going to need to stop construction immediately." I turned around and saw a woman in her late 50s, maybe early 60s, dressed in white capri pants, a lavender polo shirt, and a sun visor carrying a leather portfolio, and wearing an expression that I can only describe as practiced authority, the look of someone who's used to being obeyed without question. "I'm sorry. Who are you?" I asked, pulling out my earbuds and wiping concrete dust off my hands. "I'm Margaret Chen, president of the Pinewood Estates Homeowners Association," she said, flipping open her portfolio to show me what looked like an ID badge with her photo and title. "This structure you're building is in violation of our architectural guidelines, and you haven't submitted an application to the Architectural Review Committee. You'll need to cease construction immediately and submit the proper paperwork, including detailed plans, material specifications, and a fee of $150 for expedited review." I stared at her for a solid 5 seconds, processing what she'd just said, because it was so fundamentally wrong on every level that I couldn't quite believe she was serious. "Ma'am, I think there's been a misunderstanding," I said, keeping my tone polite and professional. "I'm not part of Pinewood Estates. My property isn't in your HOA. I'm building this shed on my own land, and I've already gotten county approval." Her expression didn't change. If anything, she looked slightly annoyed that I'd contradicted her. "I'm aware you're new to the area," she said, with the kind of condescending patience you'd use with a confused child. "But when the Hutchinsons owned this property, we had an understanding that they would maintain architectural consistency with our community standards. That understanding continues with the new ownership. This shed you are building is not consistent with our design guidelines. We require all outbuildings to match the primary residence in color and roofing material, and you'll need to submit paint samples and architectural drawings before proceeding." I actually laughed, which in retrospect probably wasn't diplomatic, but the situation was so absurd that I couldn't help it. "Ma'am, with all respect, I do not have any understanding with your HOA because I'm not a member of your HOA," I explained, pulling my phone out of my pocket. "I have my deed right here if you want to see it. There's no HOA covenant, no CCNRs, nothing. The Hutchinsons may have voluntarily cooperated with you, but I'm under no legal obligation to do so, and I'm not going to." Margaret's face tightened, and I saw her jaw clench slightly. "Whether you think you're a member or not is irrelevant," she said, her voice getting sharper. "This property borders our community, and what you do affects our property values. If you continue construction without approval, I'll have no choice but to issue fines and take legal action." I felt my own patience starting to thin because I'd dealt with bureaucratic overreach in my professional life. City councils that tried to exceed their authority, contractors who claimed expertise they didn't have, inspectors who invented code requirements, and I had zero tolerance for it in my personal life. "You have no authority over my property," I said firmly but calmly. "I'm not part of your HOA, I don't answer to your architectural committee, and if you issue me any fines or take any legal action, I'll countersue for harassment and abuse of process. Now, I've been polite, I've explained the situation, and I'm asking you to leave my property." She stared at me for a long moment, and I could see the calculation happening behind her eyes. She was clearly used to people backing down, used to her authority being accepted without question, and my refusal had genuinely surprised her. "You're making a mistake," she finally said, closing her portfolio with a sharp snap. "I'll be filing a formal complaint with the county, and you'll be hearing from our attorney." She turned and walked back toward Pinewood Estates, her visor bobbing with each angry step, and I stood there holding my concrete mixing paddle, genuinely bewildered by what had just happened. Anna came out onto the back porch with lemonade about 10 minutes later and asked who I'd been talking to, and when I explained the situation, she looked as confused as I felt. "Can she actually do anything?" Anna asked, handing me a cold glass. "She can't, right? We're not in their HOA." I shook my head. She has zero legal standing. It's like the president of a country club demanding that people who do not belong to the country club follow country club rules. It's nonsense. But that evening, I did what any prudent person would do. I pulled out all our closing documents, reread the deed, reviewed the title insurance policy, and confirmed once again that there was absolutely no HOA affiliation, no architectural covenant, no maintenance agreement, nothing that gave Pinewood Estates any authority over our property. I also did some research on Oregon HOA law, specifically ORS 94.550 through 94.783, which governs planned communities, and confirmed that HOAs only have authority over properties that are legally part of the community through recorded covenants, and our property had no such covenant. I felt confident that Margaret Chen was bluffing, that she'd realize her mistake and back off, and that would be the end of it. I was wrong. 4 days later, on Wednesday afternoon, I received a certified letter from the Pinewood Estates HOA, sent to my home address, with Margaret Chen's signature at the bottom. The letter was titled Notice of Violation and Assessment of Fines, and it was 3 pages of single-spaced text that made my blood pressure spike with every paragraph. The letter claimed that my property was subject to the architectural standards of Pinewood Estates by virtue of proximity and historical precedent, cited a section of their CC&Rs that supposedly applied to adjacent properties affecting community aesthetics, and informed me that I was in violation of Section 4.2, Unapproved Structures, Section 6.7, Failure to Submit Architectural Plans, and Section 9.3, Non-Compliance with Design Standards. The letter assessed fines totaling $500, $200 for the unapproved structure, $150 for failure to submit plans, and $150 for non-compliance, and stated that fines would increase by $100 per day until I came into compliance, which apparently meant either removing the shed or submitting it for architectural review and making whatever modifications the committee demanded. The letter concluded with a threat. Failure to comply within 14 days will result in a lien being placed against your property and potential foreclosure proceedings to recover owed amounts. I sat at my kitchen table reading this letter 3 times, and I felt a combination of fury and disbelief, because this wasn't just bureaucratic overreach. This was legal intimidation, an attempt to bully me into compliance through threats of financial consequences and property loss, and it was based on a completely fabricated claim of authority. Anna read it over my shoulder, and her reaction was even stronger than mine. "This is insane," she said, her voice shaking with anger. "They're threatening to put a lien on our house? Can they even do that?" I shook my head. No, they absolutely cannot. A lien requires a valid debt, and they can't create a valid debt by unilaterally declaring we owe them money for violating rules that do not apply to us. This letter is either gross incompetence or deliberate fraud, and either way, it's actionable. Miguel, who'd been listening from the living room, came into the kitchen looking worried. "Dad, are we going to lose the house?" he asked, and hearing the fear in my 16-year-old son's voice, because some power-hungry HOA president was threatening our home, made my decision crystal clear about how I was going to handle this. "No, buddy, we're not going to lose anything," I told him firmly. "This is just someone who doesn't understand the law trying to push us around, and we're going to make sure she understands she can't do that." That evening, I drafted a response letter, and as an engineer who works with attorneys regularly, I knew exactly what needed to be said. I titled it Cease-and-Desist Demand, and I kept it professional, factual, and legally precise. I stated that my property was not part of Pinewood Estates, cited my deed recording number, and the absence of any HOA covenant referenced Oregon Revised Statutes 94.550, which defines planned community membership as requiring recorded instruments, and demanded that they immediately withdraw their violation notice, retract all fines, and cease any further contact regarding HOA compliance. I warned that any attempt to place a lien on my property would constitute slander of title under Oregon law and would result in immediate legal action seeking damages and attorney's fees. I concluded by stating that any further harassment would be reported to the Washington County District Attorney's Office as attempted extortion. I had the letter notarized, sent it certified mail with return receipt requested, and also emailed a copy to the email address listed on the HOA's letterhead. I felt confident that any reasonable person, upon receiving a detailed legal response explaining why they had no authority, would back down and apologize for the error. Margaret Chen was not a reasonable person. Her response came 6 days later, and it escalated the situation beyond anything I'd anticipated. Instead of withdrawing the violation notice, she doubled down. The new letter, again sent certified mail, acknowledged receipt of my cease-and-desist letter, and dismissed it entirely. "Your assertions regarding HOA non-membership are disputed," the letter stated. The Pinewood Estates Declaration of Covenants, Conditions and Restrictions, as amended in 2003, includes provisions extending architectural authority to properties within 100 feet of community boundaries that impact visual aesthetics and property values. Your property falls within this zone of authority. The assessment of fines stands, and as of today, additional fines totaling $700 have been accrued. "That should end it," Daniel told me confidently. "No attorney worth their license would advise them to proceed after receiving this letter. They'll back down." But Margaret Chen, as I was learning, operated on a level of stubborn delusion that defied logical prediction. Instead of backing down, she held an emergency HOA board meeting, which I only learned about later through discovery, and apparently convinced the other 4 board members that my property actually was subject to HOA authority, based on some bizarre interpretation of an amendment they'd passed in 2003. 2 of the board members, according to meeting minutes I eventually obtained, expressed serious doubts and suggested consulting an attorney, but Margaret insisted that their HOA attorney had already reviewed the matter and confirmed they had authority. This was a complete lie. The HOA's attorney, a guy named Richard Brennan who practiced in Beaverton, later testified that he had never been consulted about my property and would have immediately told them they had no jurisdiction if he had been. But Margaret's force of personality and absolute confidence apparently steamrolled the other board members' hesitation, and the board voted 3-2 to proceed with filing a lien if I didn't pay the now $1,500 in accumulated fines within 7 days. I learned about this decision on a Friday evening when Anna called me at work, her voice tight with stress, and told me that a man had just come to our door, handed her legal documents, and said, "You've been served." I drove home immediately, breaking several speed limits, and found Anna sitting at the kitchen table with a stack of papers that made my stomach drop. Margaret Chen and the Pinewood Estates HOA had actually done it. They'd filed a lien against my property with the Washington County Recorder's Office, claiming I owed $1,500 in unpaid HOA fines, and it also filed a lawsuit in Washington County Circuit Court, seeking a judgment for the debt plus interest, attorney's fees, and court costs. The complaint was filled with false statements, including a claim that I'd been provided multiple opportunities to cure violations and chose willful noncompliance, and it cited the supposed 2003 amendment to their CC&Rs as the basis for their authority. Anna was close to tears, not from fear, but from sheer outrage. "How can they just lie like this?" she asked. "How can they file legal documents that are completely false?" I took her hand and squeezed it. Because people abuse the legal system all the time, and there are consequences for that, and we're going to make sure they face those consequences, I said quietly. This was the worst mistake Margaret Chen could have made, because now she's crossed from annoying harassment into actual legal violations, and we're going to take her and her HOA apart, piece by piece. That weekend, I didn't work on my shed. I worked on building a case. I started by documenting everything. I scanned every letter, every email, every piece of correspondence we'd had with Margaret and the HOA. I pulled up the actual recorded CCNRs for Pinewood Estates from the county recorder's online database and read all 47 pages, paying special attention to the 2003 amendment Margaret kept citing. What I found was illuminating. The 2003 amendment dealt with updating rules about satellite dishes and solar panels, and there was absolutely nothing about extending authority to non-member properties. The entire legal basis for their claim was fabricated. I also researched Margaret Chen herself using public records and social media and discovered she'd been HOA president for 9 consecutive years, had run unopposed in the last 3 elections, and had a history of conflicts with homeowners. I found references in local Facebook groups to families who had moved out of Pinewood Estates specifically to escape her enforcement tactics, and multiple complaints about arbitrary rule interpretations and selective enforcement. I reached out to several former Pinewood residents through Facebook Messenger, and 3 of them responded with stories that were remarkably similar to mine. Margaret would fixate on someone, usually someone she perceived as not respecting her authority, and would launch campaigns of violations and fines over increasingly minor issues until the family either capitulated completely or moved away. One former resident, a woman named Jennifer Patel, told me she'd been fined $3,000 over a 6-month period for having non-compliant window treatments. Margaret had decided that Jennifer's curtains were the wrong shade of white, and had eventually sold her house at a loss just to escape the constant harassment. "She's a tyrant," Jennifer told me over the phone, "and the rest of the board is too afraid of her to push back." I'm glad someone's finally fighting her. I also drove around Pinewood Estates one evening, taking photos of various properties, and discovered that selective enforcement wasn't just a pattern. It was practically Margaret's operating system. I documented at least a dozen clear violations of the HOA's stated rules that were going completely unenforced. Unapproved paint colors, oversized vehicles parked in driveways, landscaping that didn't match the approved plant list, holiday decorations still up months after the holidays. But when I cross-referenced these addresses with the HOA board members list, I found that 4 of these properties belonged to board members or their immediate family. Margaret enforced rules against people she didn't like or who challenged her authority, and ignored violations by people in her inner circle. This was going to be very useful in court. On Monday morning, I met with Daniel Kimura for 2 hours, and we mapped out a strategy that was comprehensive and aggressive. We would file an immediate motion to dismiss the HOA's lawsuit on the grounds that they lacked standing, and their claim was frivolous. We would simultaneously file our own lawsuit against Margaret Chen individually and the Pinewood Estates HOA for wrongful lien harassment, abuse of process, and intentional infliction of emotional distress, and we would seek an expedited hearing to remove the lien from my property because it was damaging my credit and creating a cloud on my title. Daniel was practically gleeful as we drafted the complaint. "This is going to be a very expensive lesson for them," he said. "Oregon's wrongful lien statute allows for damages of twice the amount of the lien plus attorney's fees, and we can also pursue emotional distress damages. We're going to ask for at least $50,000 in compensatory damages, punitive damages to be determined by the jury, and full attorney's fees. And I'm going to personally enjoy deposing Margaret Chen." because people like her always fall apart when they're actually held accountable. Our motion to dismiss and our counterclaim lawsuit were filed on Wednesday, and I had Daniel serve Margaret Chen personally at her home, which required a process server to knock on her door and hand her the documents directly. The process server reported back that Margaret had turned bright red when she saw the complaint, had sputtered something about, "How dare you?" and had slammed the door in his face after accepting service. Good. I wanted her to feel a fraction of the stress and violation she'd inflicted on us. The real turning point came 2 weeks later at the hearing on our motion to dismiss. Washington County Circuit Court Judge Patricia Thornton, a no-nonsense woman in her early 60s with a reputation for zero tolerance for frivolous litigation, heard arguments from both sides, and it became very clear very quickly that Margaret's attorney, a young guy named Scott Waverly, who had apparently been hired by the HOA specifically for this case, had not been given accurate information by his client. Judge Thornton started the hearing by asking Waverly a simple question. "Counselor, can you point me to the recorded covenant that gives your client authority over the defendant's property?" Waverly fumbled with his papers, clearly not prepared for this fundamental question, and started talking about the 2003 amendment and proximity and historical precedent. And Judge Thornton cut him off. "I didn't ask for an interpretation or an argument. I asked for a recorded covenant. Does one exist or not?" Waverly admitted that the defendant's property did not have a recorded HOA covenant, but argued that the amendment gave them authority anyway, and Judge Thornton's expression shifted from impatient to actively annoyed. "Oregon law is very clear that HOA authority derives from voluntary covenant agreements," the judge said sharply. "You can't impose covenants on property owners who haven't agreed to them. This is basic property law, counselor. Why are you wasting this court's time?" Daniel stood up and, with Judge Thornton's permission, walked her through our evidence. The deed showing no HOA covenant, the actual text of the 2003 amendment showing it had nothing to do with extending jurisdiction, the cease-and-desist letters that had been ignored, and the fact that the HOA had filed a lien despite having no legal basis for claiming a debt existed. "Your Honor, this isn't just a case of mistaken interpretation," Daniel argued. "This is a deliberate abuse of the legal system to harass a homeowner who refused to bow to illegitimate authority. My client has suffered damage to his credit, stress and anxiety, and substantial attorney's fees, all because the HOA president decided that her authority extended beyond the law. We're asking this court not just to dismiss the HOA's baseless lawsuit, but to send a strong message that this kind of behavior has serious consequences." Judge Thornton granted our motion to dismiss from the bench, ruling that the HOA had no standing to sue because they had no legal relationship with my property, and ordered the lien removed immediately. But she went further. She sanctioned the HOA and Margaret Chen personally under Oregon's frivolous litigation statute, ordering them to pay $5,000 in sanctions to be split between the court and my attorney's fees, and she issued a strongly worded order that explicitly stated the HOA had no authority, jurisdiction, or legitimate basis for any action regarding the defendant's property, and warned that any future attempts to enforce HOA rules against my property would be considered contempt of court. The courtroom was mostly empty, except for us, the HOA's attorney, and Margaret Chen, who'd attended the hearing, and when Judge Thornton read her ruling, I watched Margaret's face go through a range of expressions: shock, disbelief, rage, and finally something that looked like genuine fear as she realized she'd just been personally sanctioned by a judge. After the hearing, in the courthouse hallway, Scott Waverly pulled Daniel aside and quietly asked if we'd be willing to settle our counterclaim lawsuit. My client apparently didn't give me accurate information about the situation, he said, looking genuinely embarrassed. I had no idea the property wasn't actually in the HOA. I need to seriously reconsider my representation here. Daniel told him we'd consider settlement offers, but that our damages were substantial and growing, and that Margaret Chen's pattern of behavior needed to be addressed comprehensively. That night, Anna and I celebrated with a nice dinner at a local Italian restaurant, and for the first time in weeks, the knot of anxiety in my chest loosened slightly. But I knew we weren't done. We still had our lawsuit against Margaret and the HOA, and I wanted more than just dismissal of their case. I wanted accountability. Over the next 6 weeks, as our lawsuit proceeded through discovery, the full scope of Margaret Chen's abuse of authority became staggeringly clear. Daniel subpoenaed HOA records, including meeting minutes, financial statements, and correspondence files, and what we found was damning. Margaret had been operating the HOA as her personal fiefdom for years, making unilateral decisions without board approval, selectively enforcing rules based on personal grudges, and misusing HOA funds for questionable purposes. We discovered that she'd approved payment of over $40,000 to her brother's property management company over 3 years for consulting services that other board members didn't even know about, that she'd personally kept thousands of dollars in fines collected from homeowners instead of depositing them into the HOA account, and that she'd used HOA money to pay for personal legal disputes that had nothing to do with association business. We also found evidence of systematic harassment of multiple families, detailed violation logs showing that certain homeowners received citations every few weeks for minor or invented infractions, while other homeowners with clear violations were never cited at all. The pattern was obvious. Margaret targeted people who challenged her, who didn't show her sufficient deference, or who she simply didn't like, and she used the HOA's enforcement power as a weapon of personal vendetta. Daniel deposed Margaret in mid-October, and I was allowed to attend the deposition as the plaintiff. Watching Margaret Chen try to defend her actions under oath was one of the most satisfying experiences of this entire ordeal. She started out defensive and combative, insisting that she'd been acting within her authority, and that I was a troublemaker who did not respect community standards. But as Daniel methodically walked her through document after document, her own letters, her own emails, meeting minutes where she'd made false claims, her confidence eroded. When Daniel asked her to point to the specific provision in the CC&Rs that gave the HOA authority over non-member properties, she couldn't do it, and eventually admitted she'd interpreted the rules to mean that proximity gave them authority. When asked who she'd consulted for this interpretation, she admitted she hadn't consulted the HOA's attorney, hadn't researched Oregon law, and had basically just decided on her own that she had the right to enforce HOA rules on my property. "So you just made it up," Daniel said flatly. Margaret's attorney objected, but the damage was done. It was clear from the record that Margaret had invented legal authority that didn't exist, and had used the threat of financial harm to try to force compliance. But the most devastating part of the deposition came when Daniel asked about the financial irregularities, the payments to her brother, the unreported fine collections, the personal legal expenses charged to the HOA. Margaret's face went pale, and she suddenly became very interested in consulting with her attorney before answering questions. She invoked her Fifth Amendment right against self-incrimination on multiple financial questions, which legally was her right, but practically speaking, it was an admission that she'd done something potentially criminal. Daniel ended the deposition by asking one final question. "Ms. Chen, do you have any remorse for the stress and financial harm you've caused my client and his family by pursuing baseless legal action against them?" Margaret looked directly at me for the first time during the deposition, and I saw no remorse in her eyes, only resentment. "I was doing my job as HOA president," she said coldly. "If he had just followed the rules, none of this would have happened." That answer, preserved in the deposition transcript, would become Exhibit A in our argument for punitive damages. 2 weeks after the deposition, the Pinewood Estates HOA held an emergency special meeting. We found out about it because one of the homeowners, a guy named Margaret Chen, no relation to Margaret despite the same last name, contacted us and offered to keep us informed because he was disgusted by Margaret's behavior. The meeting was ostensibly about general HOA business, but the real agenda was addressing what Robert called the Margaret Chen problem. Apparently, word had gotten around the community about the lawsuit, the sanctions, and the financial irregularities, and homeowners were demanding answers. Several board members, facing potential personal liability as co-defendants in our lawsuit, were finally willing to break ranks and challenge Margaret's authority. The meeting, according to Robert, was explosive. Homeowners stood up one after another to share their own stories of harassment, unfair fines, and selective enforcement, and multiple people demanded Margaret's resignation. Margaret reportedly tried to maintain control, insisting that she'd done nothing wrong and that the homeowners needed to trust her leadership. But the mood had shifted decisively against her. One homeowner, a lawyer who lived in Pinewood Estates, stood up and explained in detail exactly how legally exposed the HOA was because of Margaret's actions, and warned that if our lawsuit succeeded, which seemed likely given the evidence, the HOA's insurance might not cover the damages because Margaret had acted outside her authority, meaning the costs could come out of homeowner assessments. That got people's attention fast, because suddenly it wasn't just about abstract principles of fairness, it was about their wallets. The board voted 4-0, with Margaret abstaining, to accept her resignation as president effective immediately, and further voted to remove her from the board entirely. Margaret, according to Robert, stormed out of the meeting screaming that they were all ungrateful and that the neighborhood would fall apart without her leadership. The homeowners applauded when she left. With Margaret removed from the board, the new HOA leadership immediately reached out to Daniel to discuss settlement of our lawsuit. The new board president, an accountant named Thomas Wu, was straightforward and apologetic. "We want to resolve this quickly and fairly," he told Daniel in their first phone call. "Margaret misrepresented facts to the board, exceeded her authority, and engaged in conduct that we cannot defend. We are prepared to offer a settlement that includes full compensation for your damages, removal of the lien, which has already been done, a formal written apology, and an agreement that the HOA will never claim any authority over your client's property. We'd also like to include a provision where we cooperate with any investigation into Margaret's financial conduct." Daniel brought the settlement offer to me, and we discussed it in detail. The HOA was offering $45,000 in compensatory damages, covering my attorney's fees, the impact on my credit, time lost dealing with the situation, and emotional distress. Plus, they agreed not to contest punitive damages against Margaret Chen personally, which we could pursue in a separate action. They also agreed to send a letter to every Pinewood Estates homeowner explaining that my property was not and had never been part of the HOA, that the previous board leadership had exceeded its authority, and that the situation had been resolved. For me, the most important part wasn't the money, though $45,000 was substantial. It was the accountability and the public acknowledgement that what had been done to us was wrong. I accepted the settlement with one additional condition: that the HOA cooperate fully with a forensic audit of their finances for the years Margaret had been president, and that if the audit revealed criminal conduct, they would report it to appropriate authorities. Thomas Wu agreed immediately. telling us that the new board had already voted to conduct such an audit because they had fiduciary duties to the homeowners and needed to know the full extent of any mismanagement. The settlement was finalized in early November, about 5 months after Margaret had first knocked on my door to tell me I needed architectural approval for my shed. As part of the settlement, we participated in a mediation session where Thomas Wu, on behalf of the HOA, formally apologized to Anna and me for the harassment and baseless legal action we'd endured. "This should never have happened," Thomas said, and he sounded genuinely remorseful. "Margaret Chen abused her position and the trust that homeowners placed in her, and you suffered because of that abuse. We're committed to making sure nothing like this ever happens again." Anna, who'd been carrying enormous stress through this entire ordeal, actually teared up during the apology, and I felt some of my anger finally start to dissipate. We weren't just victims who'd been bullied into silence. We'd fought back, we'd won, and we'd forced institutional change. But the story doesn't end with our settlement, because the forensic audit that the new HOA board commissioned uncovered something far worse than any of us had expected. The audit, conducted by a firm specializing in HOA financial investigations, found that Margaret Chen had misappropriated approximately $127,000 in HOA funds over a 7-year period through various schemes. Fake vendor invoices paid to companies owned by her relatives, personal expenses charged to the HOA credit card, and disguised as business expenses, fine money that was collected but never deposited into HOA accounts, and unauthorized payments for personal legal matters. The audit report was delivered to the HOA board in December, and Thomas Wu immediately turned it over to the Washington County District Attorney's Office. I learned about this from a news article in the local paper. A reporter had gotten wind of the investigation and wrote a story with the headline, "Former HOA President Under Investigation for Embezzlement." The article quoted Thomas Wu confirming that the HOA had discovered significant financial irregularities and had cooperated with law enforcement, and it mentioned that the investigation had begun after a lawsuit involving a non-member property owner who'd been illegally targeted by the HOA. I texted the article to Daniel with the message, "Karma works slowly but thoroughly," and he responded with a laughing emoji. Margaret Chen was formally charged with first-degree theft, a Class C felony in Oregon, in February of the following year. According to the charging documents, which are public record, she was accused of stealing $127,440 from the Pinewood Estates HOA through fraudulent schemes over 7 years. The DA's office offered her a plea deal: plead guilty to reduced charges, make full restitution to the HOA, and serve probation instead of prison time. But Margaret apparently refused, insisting she'd done nothing wrong and that the charges were retaliation for her aggressive leadership style. The case went to trial in June, and it lasted 3 days. I wasn't called to testify because my lawsuit was a separate matter, but Daniel attended the trial out of professional curiosity and texted me updates. The prosecution's case was overwhelming. They had bank records, forged invoices, testimony from Margaret's brother admitting that his company had been paid for work it never performed, and even emails where Margaret explicitly told her daughter to submit fake invoices for landscaping work. Margaret's defense was essentially that she'd been authorized to make these payments and that they were all legitimate business expenses, but she couldn't produce any documentation of authorization, and multiple former board members testified that they had never approved most of these expenditures and hadn't even known about them. The jury convicted her on all counts after deliberating for less than 4 hours. She was sentenced in August to 5 years of supervised probation, 1,000 hours of community service, and ordered to pay full restitution of $127,440 to the HOA plus court costs. She was also permanently banned from serving on any homeowners association board in Oregon, and the judge included a scathing statement in the sentencing order about abuse of fiduciary duty and betrayal of community trust. Margaret's husband quietly put their house in Pinewood Estates on the market 2 weeks after sentencing, and they moved to Southern California, where I imagine Margaret is probably trying to find a new HOA to terrorize, though her felony conviction would likely prevent her from serving on a board. As for Pinewood Estates itself, the aftermath of the Margaret Chen scandal was transformative in ways that went far beyond one family's vindication. The new board, led by Thomas Wu, implemented sweeping reforms that completely changed how the HOA operated. They revised the CC&Rs to include strict limits on presidential authority, requiring board votes for any enforcement action involving fines over $100 and for any legal action whatsoever. They established an independent appeals committee, made up of homeowners who weren't on the board, to review any violation claims before fines could be assessed. They implemented mandatory annual financial audits by an outside firm, with results published to all homeowners. They created a transparency policy requiring all board meetings to be open to homeowners with advance notice and published agendas. And most importantly, they adopted a reasonableness standard for enforcement, explicitly stating that rules would be applied fairly and consistently, with warnings given before fines except in cases of egregious violations. The cultural change was even more significant than the policy changes. Homeowners who'd been living in fear of arbitrary enforcement suddenly felt comfortable personalizing their properties within reasonable bounds. Community events that had been stiff and awkward became genuinely friendly gatherings, and property values in Pinewood Estates actually increased by 12% over the next 18 months, because the neighborhood developed a reputation as a well-managed community without the drama and tyranny that had characterized the Margaret Chen years. I became something of a folk hero among Pinewood residents, despite never having been part of their community. I'd occasionally get stopped at the grocery store by people who recognized me from the news coverage and wanted to thank me for standing up to Margaret, and Robert Chen invited Anna and me to a community barbecue where we were greeted with applause and thanked by at least a dozen families who said our lawsuit had freed them from years of harassment. It was gratifying, but also bittersweet, because I'd never wanted to be in this fight in the first place. I'd just wanted to build a shed and live peacefully on my own land. As for that shed, I finished it in September, and it's beautiful. 16 feet of cedar siding with a metal roof, exactly as I'd planned, sitting 45 feet from the property line with my county permit displayed proudly inside. I use it for woodworking, and I've built about 24 projects in there over the past year. Cutting boards, picture frames, a dining table for our kitchen that Anna loves. Miguel uses part of it for storing his music equipment. And on weekends, you can hear guitar riffs drifting across the property. Nobody from Pinewood Estates has ever said a word about it, because they all know exactly what would happen if they did. Anna and I still live in our farmhouse, and we've made even more improvements. We added solar panels, built a greenhouse for Anna's vegetable garden, and I'm currently designing a workshop expansion that will double my woodworking space. We've never received another letter from the HOA, and the new board actually sent us a holiday card last December with a handwritten note from Thomas Wu saying, "Thank you for holding us accountable. Our community is better because you stood up for what was right." I keep that card on my workbench in the shed as a reminder that fighting institutional bullying, even when it's exhausting and expensive and stressful, is worth it. Not just for yourself, but for everyone else who's suffering under the same abuse and doesn't have the resources or knowledge to fight back. Margaret Chen thought she could intimidate me into compliance because that's what had worked for her for years. But she made one critical miscalculation. She targeted someone who had the knowledge, resources, stubbornness, and legal understanding to fight back. And that one mistake unraveled her entire empire of petty tyranny and revealed criminal conduct that sent her life into a tailspin she'll never fully recover from. So if you're dealing with an overreaching HOA, a power-hungry board president, or anyone who's using institutional authority as a weapon of personal control, here's what I learned from this experience. Document everything. Every letter, every email, every conversation, every interaction. Keep records, because documentation is your most powerful weapon. Know your rights. Actually read your deed. Understand whether you're legally bound by HOA rules. Research your state's laws about HOA authority and homeowner protections. Don't be intimidated by official-sounding letters or legal threats. Many HOAs count on homeowners being scared into compliance even when they have no legal basis for their demands. Get professional help early. As soon as the situation escalates beyond simple correspondence, consult a real estate attorney who specializes in HOA law, because the cost of prevention is always less than the cost of fixing a situation that's spiraled out of control. Stand your ground when you're legally right. Bullies, whether on a playground or in a boardroom, count on people backing down, and the moment you show you won't be pushed around, their power evaporates. And finally, think about the broader impact. When you fight back against abuse of authority, you're not just protecting yourself, you're protecting every future person who might have been victimized by the same abuse. Margaret Chen terrorized dozens of families over years, and she only stopped because one family refused to be terrorized. Your fight might be that family for someone else. Now I want to hear from you. Have you dealt with an HOA that exceeded its authority? Have you been threatened with fines or liens for violations you didn't actually commit? Have you ever had to fight back against institutional bullying? Drop your story in the comments below, because I read every single one, and your experience might help someone else who's going through the same situation right now. If this story gave you that satisfying feeling of justice served and tyranny destroyed, do me a huge favor and smash that like button. It genuinely helps the algorithm push this content to more people who need to hear these stories. And if you haven't subscribed yet, hit that subscribe button right now and turn on notifications, because I've got another story for you tomorrow that's going to blow your mind. Speaking of HOA boards that made catastrophic mistakes by targeting the wrong person, tomorrow's story takes everything you just heard and escalates it to a level that's almost hard to believe. Picture this: an HOA board president so drunk on power that when a homeowner changed their own door locks, completely normal home maintenance that every property owner has the right to do, she called 911 claiming it was illegal and that she owns this neighborhood and has the right to access any property whenever she wants. What this Karen did not know was that the homeowner she was targeting wasn't just some random resident. He was a civil rights attorney who'd spent 15 years litigating unlawful search and seizure cases, and he had a very clear understanding of exactly how many laws she'd just violated with that 911 call. The police response? Let us just say the body cam footage became evidence in a federal lawsuit that exposed a pattern of illegal HOA conduct so egregious that fundamentally changed how HOAs operate in that entire county. This Karen didn't just lose her position on the board. She faced federal civil rights charges, and the HOA itself was effectively dissolved and reformed under court supervision. The legal destruction was so complete and so thoroughly documented that law schools now use the case as a teaching example of HOA liability and federal civil rights violations. Tomorrow's story is hands down one of the most satisfying, legally complex, and absolutely devastating takedowns I've ever covered, and you absolutely cannot miss it. We're talking about an HOA president who thought she was above the law, discovering in the most painful way possible that constitutional rights do not stop at your property line, and that calling 911 to enforce imaginary HOA authority is a federal crime when it violates someone's civil rights. Make sure you're subscribed with that notification bell turned on, because this story drops tomorrow at the exact same time, and trust me, watching someone who claimed to own the neighborhood get completely destroyed by the legal system is the kind of justice that'll make you want to stand up and cheer. See you tomorrow.